All right, welcome back. Today we're going to be talking about what is a trust and some of the important parts of a trust. So today we have Jennifer McGibbons from your law firm, right? Sullivan, McGibbons, and Crickard now. Is that correct?
That's
Yeah,
correct. That's
there we
it.
go. I got lucky there. So what is a trust? Let's start with that.
So typically, there's two different types of trust that we hear about. One is a revocable or a living trust, and the other is an irrevocable trust. A revocable trust is probably the one that I talk about with a bit more frequency. That's essentially just a document created by an individual for the benefit of that individual, and it confirms who's going to receive the assets when that individual passes away. But can be changed and revised at any point in time by that individual and is still owned and controlled by that individual. An irrevocable trust is a little bit different. That's created by an individual for the benefit of someone else. So they're transferring or shifting assets to someone else, and then they name or designate who is going to manage or control those assets, and that's the trustee. So those assets are no longer a part of that creator or individual's estate and do not belong to the beneficiary either. So it's kind of a nice way of shifting assets to someone else, but still controlling how and when that individual can receive the assets. General or common terms we see whenever we're talking about trusts are trustee. So who's managing the assets and distributing the assets? The grantor, trustor, or settlor. So that's the individual who created the trust and moved assets to it. And then the beneficiary. So that's the person who is receiving the benefits of those assets, whether it's income stream or principal, but they are the ones receiving the benefits. And typically, the reason why we talk about revocable trusts is because they're a substitute for a will here in California. So, here in California, we do our best to try and avoid formal probate or estate administration. And one way to do that is by having a trust in place.
That's really good to for Californians to have the ability to kind of have the trust be the document for your estate planning. I think one of the other things that you've talked about in the past is the irrevocable trust also provides some protection from the beneficiary.
Correct. So again, it's not technically the beneficiary's assets because they're controlled and managed by a trustee. And so by having that formality in place from a third party creditor perspective, or in the event of a divorce, it's not technically assets belonging to the beneficiary until the assets are distributed out of the irrevocable trust and directly to the beneficiary. But while they stay in that trust structure, it's separate assets from the beneficiary's personal assets or estate.
Yeah, so like if you have mom and dad over here and you have your child over here, there's this like third entity that's hanging out there, which is the irrevocable trust, which can provide some protection as well as some restrictions on distributions and whatnot. So
Correct.
it's
Yeah,
important.
provides a measure of protection. It's going to have a separate tax ID number, so it's going to have separate income tax filings every year. And correct, it's a great way for mom and dad to control how and when their child is receiving the assets. So you can protect the beneficiary from himself or herself, and or you can provide the beneficiary with protection or insulation from third parties.
That's awesome. So I guess if the trust substitutes as a will in California, what's the difference between a will and trust then?
So, a will, if a person dies with a will in place, their assets may still be subject to a formal probate administration, which is essentially a court supervised and regulated process. And here in California, even a really simple, straightforward probate administration can take about a year, year and a half, sometimes even longer. And there's also costs associated with that. So people here in California, unlike other states that have a very simple probate or estate process, here in California, we look to avoid that process. And one way to avoid that is by having a trust in place and moving the assets or your assets into the trust. Also, a revocable trust provides confidentiality. It's a private document, whereas if you have to probate your will, that's a matter of public record. So if you're a fan of TMZ, you can go on that website and Google all sorts of different people's wills. If they've been subject to a probate, you can see all the different provisions associated with that will. Whereas if you have a trust in place, really no one's entitled to see those provisions until the trust goes from a revocable to an irrevocable. And even then, it's only the beneficiaries who are entitled to see the terms of the trust. Yeah. Also, a revocable trust, you're signing it while you're alive. It's a living document, as I referenced earlier. So it's going to deal not only with a death situation, but also incapacity. And we're all living longer these days. And so another big part of what we work with clients on figuring out is not only how are your assets going to be distributed at death, but also what if you become incapacitated? How are we going to make that process easier for you as an individual so that your life continues in the appropriate manner? So a trust will detail not only death provisions, but also incapacity provisions. But a revocable trust does require the funding of it. So moving assets out of your individual name into the name of the trust. It will not limit your ability to sell or buy or control those assets, but it does technically need to be titled in the name of the trust for it to work.
Yeah, there's a lot of good things there to kind of unpack. I think a lot of people would rather have their personal business be kept private, right?
Yep.
So that's the number one thing that I think would differentiate a trust and a will. But another thing is before COVID, I think San Diego, that both Jennifer and I are in San Diego. And San Diego, I believe, had 3 probate courts pre-COVID. And then COVID happened, and I think it went down to 1. Correct me if I'm wrong. It's something like that.
So we've seen a lot of shifting with the judges of late with probate. It was 3 for a period of time, then it was down to 2. Now it looks like we're going back to 3 in the near future.
Okay.
We just had a judicial update, and they are looking to add another judge. But yeah, their calendars are very, very busy. So
that's what I was going to get at. It's like, what would you say is the average delay when you're dealing with the court system?
Well,
I mean, there you go.
So yeah, exactly. There's your answer right there. So to get a probate opened, there are requirements as far as what that timing is to get an executor appointed or a personal representative appointed. But to close a probate administration, I mean, even with no accounting being required, everyone's consenting to it, everyone's happy. Sometimes when you file your petition to close, you will not get a hearing date for 6 to 7 months until after you filed that petition. So what that means essentially is it's frozen until the court has their hearing and issues that order. So you're just in this frozen period of time where you still can't conduct business. So it's a very complicated and kind of cumbersome process that we try very hard to avoid here in California.
Yeah, it's this weird limbo state, if you will. The other thing, the conservatorship, I think for most people, incapacity happens slowly, right? And then you all of a sudden realize, or if you're honest with yourself, you realize that you're not able to make these decisions, and setting up a plan then when you've already passed that point is very difficult, and so this. If you have loved ones, this is a way to structure and make sure your investments, your financial affairs are dealt with your opinions while you're able to, and you can have that impact. And I think that's very important.
I agree.
You mentioned that. And then obviously this funding part, I think if there was a hole in estate planning, that hole would be, a lot of people have this shiny binder on their shelf that says estate plan or trust, living trust, revocable trust, but oftentimes they never get funded.
Correct. Correct. So I've created trusts for clients in the past, and then they pass away, and lo and behold, there's an asset that's not titled in the name of the trust. And so even though we have this trust in place, you still have to go through the probate administration to get those assets moved into the trust. And that certainly is not an ideal situation. It kind of defeats the whole purpose of putting the trust in place. Also, I find sometimes you move, let's say, for example, your residence into the trust, and then you want to refinance. And what sometimes happens with mortgage holders is they make you take it out of the trust before they allow you to refinance, and then the client forgets to put it back in. Yeah. So their recall is, no, it's in the name of the trust. My recall is, no, it's in the name of the trust. I did that deed with you when you came in and met with me. But sometimes things happen later, and things just slip through the cracks. So that's why we always have a will in place as well for clients that says, if I have any assets that are just in my name, give it to the trustee of my trust. So it'll still hit the trust. It's just you're going through that probate administration to get the asset over to the trustee.
Yeah, no, it's very important. But, not all things transfer by trust, right? Like if you have an IRA or a 401k, you're probably familiar with filling out a beneficiary form, or life insurance has a beneficiary form. A lot of people, they own things as joint tenants with rights of survivorship, or so there's operation of contract and there's operation of law, right?
Correct.
So what are the fundamental differences there?
So essentially, as I mentioned, a trust avoids probate. There are other ways of holding assets that you also avoid probate. And you mentioned there's contracts. So you can have a beneficiary designation attached to your asset. We commonly see those with 401ks, retirement, life insurance. But you can also have a bank account or an investment account that's just in your individual name, and you have a beneficiary designation attached to that. Those are commonly referred to as pay on death or transfer on death accounts. As long as the beneficiary is living, when you pass away, it automatically goes to that beneficiary once they have a death certificate. So it's a very streamlined way of certainly getting assets over to a beneficiary. The only time that becomes problematic is basically two situations. One is you have a minor. So minors cannot receive assets. So that'll create the need for a guardianship. The second is you have a beneficiary where you don't want them to get these assets just outright when you pass away. So how do we put it in a structure where you can control that? That's when a trust is a better option for those types of situations or assets, even though beneficiary designations work great for certain situations. And then also joint tenancies. So that's a common way that we see spouses holding assets. When one joint tenant passes away, or husband and wife community property with right of survivorship, that automatically goes to the surviving spouse. Super simple way to transfer assets over. But do they have minor children? Do they have beneficiaries who are problematic? What if something happens to both of them at the same time? That may be remote, but it's still a part of what we discuss and review in our estate planning process. Something happens to both spouses, joint tenancy essentially goes to the estate, and you're dealing with a probate administration again.
Yeah, I think these are all big points to kind of take in. But I think one thing that's also true is that people are living longer.
Yes.
And as people live longer, they tend to need more help.
Uh-huh.
And the biggest gap that we've seen in our practice here is that these type of accounts, if you need to withdraw funds and you're incapacitated, and you don't have a power of attorney or any of those other documents, it's going to be very tough to get access to these accounts if that at all, right?
Correct. Yeah, absolutely.
And so, go ahead.
I was just going to say, and financial institutions are really strict about that because they, understandably, they don't want to be sued for having distributed or taken instructions from someone not the principal, not the one who created the account or who owns the account. So yeah, trust is important, but also having a financial power of attorney is very important as well. And as you noted, Amar, when you have capacity and when you know what you want, that's a great and ideal time to say who's going to do that for you if you cannot for yourself.
Yeah, absolutely. So now, what could be some issues when you're thinking about setting up a trust? I think there's, you know, everyone's situation is unique, and some, but what are some key issues that people have to walk through when they decide, you know what, we're going to set up a trust?
Yep.
Here are some things we need to consider.
Yeah, so typically there's 5 main categories that we talk about whenever we're setting up a trust. And it's 5 if it's spouses, it's 4 if it's an individual. Number 1 is who's going to get the assets when you pass away. If you're married, how are you going to structure that when one spouse dies and there's still a surviving spouse? So who's going to receive the assets when you die is always question number 1. And that, as you noted, will really depend on the particular client's situation, and should be different based on that individual situation. But certainly for spouses, if they're married, we're talking about, is it going to go outright to that surviving spouse when first spouse dies? Is it going to be held in a trust, an irrevocable trust, as we mentioned earlier, for the benefit of that surviving spouse? If so, what are those distribution provisions? What are the parameters that you're going to put in place for that surviving spouse? Oftentimes, we see those irrevocable trusts in situations like blended families. We have second or third marriage. You have children from a prior marriage. You have assets that you acquired prior to getting married. How are you going to structure that so it still works and you're still benefiting your surviving spouse, but also not creating issues with your children? So we spend a lot of time, particularly with blended families, talking about how to structure it that way. But with spouses, it's always question number 1. How are we going to structure it when the first spouse dies? And then also, how are you going to structure it for any other beneficiaries? Are your beneficiaries minors? Are they adults, but just not yet at an age where you feel comfortable with them managing and controlling those assets for themselves? So how are you going to structure those distribution provisions for the beneficiaries? And we will typically go over several different scenarios, because what if both spouses die at the same time? Then it's going to go to the kids. What if one of the kids is not living at that point in time, but has children or doesn't have children? So what if something happens to all of you? You're on a family trip. So we walk through all of those different scenarios, confirming where those assets will land, or to whom will they go to if something catastrophic happens, or if something basic happens. You've covered it in all of your bases in the trust. So those are always important, discussions that we have with clients when we're talking about the trust structure.
Yeah, I think all those are very important, and especially with the blended family. I remember one time we were working with a family where it's husband and wife, second marriage type situation. One spouse passed away, and the surviving spouse got income from the decedent spouse's trust. But the stepchildren, or his children in this case, there could be some animosity. It changes the family dynamics, right?
Absolutely. Yeah, absolutely. And so then that leads actually to the next slide, which is who's going to act as trustee. So that's really who's going to receive the assets, how are they going to receive the assets, and when, and then who's managing that. Who's the trustee is really the second most critical part of when we structure this trust. And again, we typically want flexibility in the document to change the trustee. Certainly with a revocable or a living trust, we have that automatic ability. But even with irrevocable trusts, we want the ability to make changes to who's acting as trustee. But that person or trust company is going to have a lot of power. They're going to be managing the assets. That's buying, that's selling, that's financing. They're going to be distributing the assets based on the terms of the trust that you've set up. Have you given the trustee full discretion or unfettered discretion? Well, then it's up to them to decide when and how that beneficiary is going to receive the assets. Have you put a standard in place, meaning they can get the assets, they can get all the income, like you mentioned, Amar, or they can get principal for their health, their education, their maintenance, and their support. It's the trustee who's the one who's making those decisions as far as when those assets are distributed out to the beneficiary.
Yeah, no, that's good. So let's take a look at some examples. So this is, following, I guess, a single individual
Correct.
in the estate planning process. So why don't we walk through this?
Yeah, so whenever I meet with clients, obviously we're talking about a lot of information and a lot of different scenarios, and we're putting together different documents that have a different impact on your estate plan. So I love flowcharts. I find that they're a great way for the client to visualize their estate plan, and it's also one page. So rather than having to go through a 40-page trust, or find your healthcare directive, or find your financial power of attorney, or your will, and go through those separate documents, you have a snapshot of what the estate plan looks like on a single sheet of paper. And so it's really helpful for the clients to kind of understand what their estate plan looks like, but also in the future, they want to make changes to their estate plan. We pull out this flow chart and kind of start there. So, the big box at the top in green, right in the middle, that's your trust. So that's the main part of your estate plan. And the other three documents kind of work around or complement that trust based on the situation. And then we always have, a gray line depending on, is it spouses? So this is a single individual. So there's just one death. So in this situation, person who created the trust, they've now passed away. Where are the assets going? And right here on this flow chart, you can see, where is it going? Are there taxes that need to be paid? Are there different specific gifts that are going out? Who's getting the residue when you've done all of those specific gifts? We've also color coded them just to make it a little bit clearer as far as certain documents are revocable or amendable. You can change them. Once that death hits, maybe some of this documentation becomes irrevocable at that point in time, or no longer applicable, like your financial power of attorney. That's no longer effective once you pass away. Your will can't change it once you pass away. So we like to color code these documents now just to make it a little bit clearer about what you can change and when.
No, this is great. I think for most people, reading the estate planning documents makes their head spin.
Yep.
And seeing a visual representation is definitely a lot easier. So, and then this is an example for like a married couple where
Correct.
There's a survivor's trust and potentially a decedent's trust.
Correct. So this is an example of what we refer to commonly as an AB disclaimer. So we have that first gray line where now one spouse has passed away. All the assets are flowing to a survivor's trust. That box is still green because surviving spouse can still make changes to that trust. But we've given surviving spouse the ability to create an irrevocable trust if they want. There's typically situations or reasons where we'd see the creation of that irrevocable trust, but it's an option as opposed to a requirement. But if the surviving spouse does decide to create that trust, it is irrevocable. So the assets you move into there, you can't change the distribution provisions. And then we have the second line again with now surviving spouses passed away. Who's receiving the assets? How are they receiving the assets? And we include that in the flow chart there.
Cool. And then this is, I guess, a different version of that, right? Essentially.
Yeah. So this one, rather than it being an option to create that bypass or irrevocable trust, otherwise everything's flowing to the survivor's trust, this is splitting it. This would be a common plan that we'd see with a blended family. We have spouse one and spouse two, their respective shares of the trust. Surviving spouse's share is going to go to a survivor's trust. It's green, it's revocable, amendable by surviving spouse. It's surviving spouse's assets. The other side, though, represents deceased spouse's assets that are required to go to an irrevocable trust. So there's no option there or consideration. It must go to that irrevocable trust structure. And it provides, again, some protection, some insulation for surviving spouse. It also provides some assurance to first spouse to die that their assets are going, if there are any remaining, to the beneficiaries they've designated in that irrevocable trust structure. So yeah, so it's just another example of a different scenario with spouses. Again, a bit more common when we see a blended family situation or a lot of separate property or different assets that are being brought into the marriage that you just want to deal with a little bit differently.
No, this is great. So I think, you know, we've covered a lot of things about trust today, and hopefully this is, you know, a basic framework to for reasoning why you should consider having the proper estate planning documents. I think in our next video, Jennifer, we should probably dig a little bit deeper into, like, how do you choose the right trustee? Like, who's the right person for that? Because there could be several variables there that could influence your decision.
Correct.
But if you have questions about your estate plan and you're in California, please reach out to Jennifer or myself, and we'll be more than happy to help. Thank you for watching.
Thank you.
Thank you.